message you, but you may not see my messages. So perhaps it's important that you time yourself as well.
Perfect. Okay, we can start. Hi, my name is Sonya Cotton and I am doing my PhD at University College Dublin. And first I would like to start off by apologizing that I've actually changed the title slightly, and I also will not be talking about the thing in the abstract. I'll be talking about something much narrower. But before I go into that, I want to give some context. So in 2018, in the aftermath of nationwide student protests calling for free decolonized education in South Africa, and in the context of conversation about changing our property law in the Constitution to allow for expropriation without compensation, the High Court and the Constitutional Court of South Africa made two judgments which effectively gave communities without formal land title informal land rights trumped mining title and common law notions of property. And even in cases when the traditional authority had consented to the land transfer, the court found that no, the people were not consented. So at the same time as it looked like top-down legal change for social justice was really possible, the South African government prepared to introduce a new bill called the Khoisan and Traditional Leadership Act. Sorry, I might be muddling the name, but effectively it gave unfettered power to traditional authorities, reinforcing not only apartheid boundaries of tribal territory, but also very colonial imaginations of what it means to be customary. So my presentation comes out of this contradiction of grappling with what was going on in South Africa. And I'm really going to be talking about today, in the context of African legality, to what extent is pluralism really possible? And yeah, so I will be looking at South Africa, Zimbabwe, Namibia, and Botswana. And this is a comparative exercise. And the reasons for these countries include the geographic proximity, and in the context of the artificiality of colonial borders, it means there's shared ethnicities, languages, and landscapes. But further, there's an overlap of colonial experiences, because with the exception of Namibia, who was colonized by South Africa, we all kind of experienced British colonization. And there's furthermore kind of Southern African Development Community regional identity. And if you look at the law, there is borrowing, there's judicial dialogue. So, and also all four have mineral resources. So it becomes interesting from the context of how much pluralism is allowed when there's diamonds. So before I begin, I want to talk a little bit more about legal pluralism. So originally it emerged in a very colonial context, associated with indirect law. So Britain allowed limited forms of traditional authority and traditional courts only so far as it did not, it was not repugnant to natural justice and morality in any written law. And the kind of term official customary law is used in some literature describing the customary law made in this period as artificial, made by colonialists and kind of elites, traditional elites who kind of wanted to protect their own interests and didn't necessarily reflect what people are doing. But I mean, there is debate about this term as, but anyway, for later, you get this movement away from this, colonial legal pluralism towards a more socio-legal approach, drawing from Ehrlich's living law, this idea that law is social, culturally embedded. And you get Griffiths in 1986 talking about strong legal pluralism, which is not just Africa, everyone's pluralistic, because no matter who you are, you're not just guided by the law. And weak legal pluralism, which is in the context of Africa when the state recognizes pluralism. So, and at the same time, you also, with kind of more critical approaches to legal pluralism, you have kind of the rise of the international rise of indigenous rights, which recognizes land, the spiritual, cultural, and ecological dimensions of land, and you get more historicizing the link between Western property paradigms, colonialism, spatial injustice, and even sovereignty. But that's, yeah, just background. So just with all that in mind, when I'm looking at legal pluralism, I'm kind of looking firstly, to what extent are African customary laws substantively recognized? So this is law that emanates from communities and not the colonial imagination of what the customary looks like. And two, to what extent is pluralism or departure from colonially received notions of property possible? And then I put a note about terminology, but just because I want to get through so much, I'm going to hope everyone read it very fast. And the second term I want to describe is post-colonial African legality. And I should say this refers specifically to Anglophone Africa, because Francophone African countries have their own dynamics. And what I define as post-colonial African legality is constitutionalism and deference to human rights discourses, notably but not exclusively group rights. And secondly, the affirmation of African knowledge systems formerly repressed under colonialism, which is at least interpreted in Southern African legal scholarship as associated with the right to culture. So my theoretical framework for looking at laws is I am very much guided by linguistic anthropology, which sees text as a socially embedded phenomenon, which looks at silence and power and authorship, and the notion that a text might have many audiences, that a law, for instance, could be saying something to the international community, but something else to its citizens, and something else as interpreted by courts. And even though my presentation is not about gender, I'm guided by African feminist jurisprudence, which really has been grappling with the so-called rights versus culture dichotomy in sophisticated and brilliant ways. So first of all, just, finally, before I start, these are all the laws I looked at. There are gaps, specifically the case law of Namibia, because I couldn't find much, but I'm in the first half of my first year of my PhD. So this will be revisited, and hopefully I will, keep coming back to this. But I looked at the constitutions, and all of them look pretty great from the perspective of recognizing pluralism. They all have very expanded definitions of property. They all affirm and protect African customary laws, and they all, except for Botswana, which was written in the 1960s, so you can kind of guess why, they have some sort of restorative or transformative intent. And this is incredibly strong if you read the preambles. Botswana, furthermore, makes certain provisions exempt from the Bill of Rights. For instance, certain features in access to free trial are exempt from traditional authorities. So it looks in a way that just from the Constitution, it looks like traditional leadership actually is higher than the state as an institution. But then when you look at the laws, it looks a bit more grim. In all cases, except for South Africa, who or what defines the traditional community, and therefore what can be land, it's always the state, except for South Africa, which refers to shared rules. And as Professor Diala, who is here, and I are argued in a forthcoming paper, shared rules is a very legal, positivist, and not ideal way to handle this. And if you read the fine line between the text, ultimately the control of customary law is the land board, which in Namibia excludes traditional leadership. And if there's minerals in it, then it's the president's in the case of Botswana. And South Africa, if you read the laws, it looks like the community. And it looks like I'm kind of biased towards South Africa because I'm South African. But at this point, I also wanted to flag that only 13% of the country, but a third of the population is in land that would be governed by this law. So it's worth being critical about what it means if South Africa has very progressive legislation in this context. So basically one of my conclusions is that is there pluralism? I would say there's anxious pluralisms. There's types of pluralisms. There's bureaucratic or common law pluralism, which is exemplified in, I would say, Zimbabwe's Traditional Leadership Act, Customary and Local Courts Act, where you have to minute detail who a traditional leader is, who comes below them, what their power is, what their equivalent in the common law is, and also their uniforms, if applicable, their salaries. So it's really a bureaucratized type of pluralism. Then you have a privatized pluralism, which you would really see in the case of Botswana, where they have the recognition of tribal privatized lands in the tribal grazing lands policy, and how in the Tribal Lands Act, Article 15, grounds for cancelling a customary land right includes not being productive in an economic sense. If you don't use the land productively, your customary rights cancelled. So there's a strong incentive, to engage in economics and so forth. And then what I call prescriptive pluralism, which, it really struck me with Namibia, how in their Communal Land Reform Act, all communal land may not have fences. Fences are punished. And just these kind of very rigid ideas of what it should look like. No foreigner may approach, if a foreigner wants to use the land, they have to approach the minister. It also makes me think of Botswana, who, even though they have the strong customary position in their constitution, they have a list of who is a tribe. And then finally, decentralized pluralism, which I would say is South Africa, where you have technically the common law and the customary law are equal, only trumped by the constitution, and you kind of have the constitution and then these abstract things called shared rules, which kind of govern it. So it's not great, but there is some good things too. So in the case laws, notably in South Africa and to some extent Botswana, there are cases where the judiciary is really interpreting kind of the purportive spirit of not just their constitutions, but kind of notable indigenous rights discourses and regional documents, for the benefit of communities and not traditional leaders necessarily. And then this is a little bit more esoteric, but in jurisprudence regarding the marriage law, you have often reference to living law in which law is recognized as something that is not only socially embedded, but that needs to change to better serve its communities. And then you have Ubuntu or Boto jurisprudence, which is the concept in African philosophy of I am because you are, which is obviously kind of associated with the more expansive notion of property. And but it's important not to over rely on the judiciary for multiple reasons. One is it's expensive, it's cumbersome. If these are rural communities, there's no access to justice, but also because even when the judiciary rules in these progressive ways, the outcomes aren't necessarily good. In the case of Botswana, the government just didn't follow through with the judgment. And in the case of South Africa, in Beleni, the activists are now being harassed and face violence. So it's important to be cautious. And then another tentative success is just kind of untapped openings because, for instance, areas that could be explored. So the Constitution of Namibia defines authorities, and it includes community as an authority. And finally, which I'm not really going into in this presentation, a success would be community action, people being mobilized. So finally, to conclude, I suppose, just to reflect on the mismatch between constitutions and laws. And arguably, there is some kind of cruel irony in which the vast degree of state supervision perpetuates a kind of colonial paternalism. And there's this very strong theme of translating customary property law through a communal prism. So pluralism is allowed, but what is recognized is very specific. And this has really important implications for land rights, because a law can look like it's empowering people while simultaneously stripping people of land rights. And finally, pluralism is political, but its scope is far more than political in the context of global climate change, land grabs, etc. I would argue this is a really important question to everyone. I mean, especially the communities involved. And finally, just my last slide is next steps. So social legal fieldwork. examination of people not recognized as official within the official scope of customary. And because I only have a few more seconds, I'm not going to talk too much about it, but my PhD falls part of a wider project, ERC project, in which we look more broadly at how the definition of property in international law facilitates justice and injustice. Thank you very much.
Thank you very